I will call the next case, cause number 65863, the matter of Geoffrey C. Mousseau, which is a compulsory discipline case. Ms. Cates, are you appearing for the commission on this one as well?
Yes, Madam Chair.
And Mr. Mousseau entered the courtroom. I don't see anyone. So, Ms. Cates, you can proceed. And I think if we skip to the conviction, we'll be good.
Can do. May it please the board. This is a compulsory case based on respondent's conviction. Bear with me on this one, just this one, and I'll skip to the judgment. Count 8, conspiracy to commit bankruptcy fraud in violation of 18 U.S.C. 371. Counts 9 and 10, fraudulent concealment of property in bankruptcy in violation of 18 U.S.C. 152.1. Count 24, false statement in bankruptcy in violation of 18 U.S.C. 152.3. Count 25, false oath in bankruptcy in violation of 18 U.S.C. 152.2. And count 26, withholding records in bankruptcy in violation of 18 U.S.C. 152.9 in the United States District Court, Central District of California. The petition for compulsory discipline was filed on September 8, 2021. The first amended petition for compulsory discipline was filed on February 11, 2022. Respondent was personally served with the first amended petition for compulsory discipline and notice of hearing by Sarah Thompson, a private process server, on February 24, 2022. Proof of service has been on file since April 11, 2022. On or about February 7, 2007, an amended judgment and probation commitment order was entered in cause number 204-CR-01697-GAF, styled United States of America versus Geoffrey C. Mousseau in the United States District Court, Central District of California, wherein respondent was found guilty of count 8, conspiracy to commit bankruptcy fraud, counts 9 and 10, fraudulent concealment of property in bankruptcy, count 24, false statement in bankruptcy, count 25, false oath in bankruptcy, and count 26, withholding records in bankruptcy. Respondent was ordered to be committed to the custody of the Federal Bureau of Prisons for a term of 21 months, with the term consisting of 21 months on counts 8, 9, 10, 24, 25, and 26 to be served concurrent to each other. Respondent is ordered that upon release from imprisonment, he is to be on supervised release for a term of 3 years. This term consists of 3 years on each of counts 8, 9, 10, 24, 25, and 26. All such terms to run concurrently. Respondent was further ordered to pay a special assessment in the amount of $600. The court further ordered that respondent shall cease to engage in the practice of law, shall notify the California State Bar, the Texas State Bar, and any other licensing body in any place in which he intends to work of his conviction herein, and shall not practice law in either California or Texas or engage in any licensed profession until given permission by the respective licensing authority. As a point of, in case there was a question about it, we were not notified of Mr. Mousseau's discipline until Mr. Mousseau attempted reinstatement in both California and in Texas. And so we just learned about this in 2019. When I called to discuss this with him, he asked me how he could apply for reinstatement here, and I said, well, you're not instated here. However, if you're telling me about this California discipline, then I'm going to have to institute a compulsory discipline. So for any questions of why it took so long, that's why it took so long. And he said he would agree in 2019 to resign in lieu of discipline, and we tried that for about a year, and then COVID was going on at the same time, so now we are here.
Okay, you did wonder about the last time.
I figured you might, and so I was happy to tell you. At this time, I would like to offer petitioner's exhibits. certified copy of the first superseding indictment filed in the underlying criminal matter. Exhibit 2, certified copy of the judgment and probation commitment order filed in the underlying criminal matter. Exhibit 3, certified copy of the amended judgment and probation commitment order filed in the underlying criminal matter. Exhibit 4, my original affidavit attesting to the fact that respondent is the same person as the person identified as a defendant in the underlying criminal case. And Exhibit 5, the original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated April 5, 2022, which indicates that respondent is licensed but not currently authorized to practice law in Texas. I would ask that these exhibits be entered at this time.
Exhibits 1 through 5 are good. Yes.
We respectfully seek entry of judgment of this matter.